Good morning. Happy Wednesday. There's a kerfuffle going on in Leon Valley. Justin Pulliam has her lesbian panties in a twist over an ethics violation, apparently. Now, to be full disclosure, I haven't watched any of Pulliam's videos because I can't bring myself to do so, but I've seen his thumbnails, and that's good enough for me. Now, what's going on in Leon Valley, I don't think is that big of a deal. I've been hypercritical of Leon Valley in the past when I felt it merited me being critical of them. But I don't believe that I am biased in either direction. I'm going to take each situation as it arises and look at it impartially, or at least to the best of my ability, look at it impartially. What happened in this particular case is the mayor disclosed Attorney Billings. Back in the summer, the city council was thinking about taking action against a city council member who was accused of harassment. They ended up removing him, but before they did so, they consulted with an attorney, as most people with the funds and the foresight are wont to do. The attorney, of course, charged for his services because that's what attorneys do. It is literally their job to give legal advice, and they expect to get paid for it. So he submitted his attorney billings. Now, on the attorney billings, generally speaking, what attorneys do is attorneys break down exactly what they're billing you for. So I spent 0.3 hours doing legal research at the law library. I spent a tenth of an hour reading your email from Tuesday. I spent another tenth of an hour responding to your email from Tuesday. I spent a half hour on a conference call with opposing counsel, etc. Now, you might think this isn't a really big deal, but in most states, in California and Texas, attorney billings are considered to be attorney-client protected information. They're subject to an evidentiary protection. The attorney-client privilege is a privilege that protects from disclosure the statements made between an attorney and a client, or vice versa. And that privilege is in place to promote the frank, honest, open communication between a client and an attorney, so that the client can know they can say whatever they need to say to the attorney and it won't be disclosed. And so the attorney can give legal advice, strategy to the client without the other side being able to simply ask for that legal strategy so that they can counter it. So it's there are exceptions, obviously. In California, I've dealt with this quite a bit. You can still request if attorney fees are at issue, you can still request the billing statements, and they will typically redact the billing statements. But as long as it's redacted, they'll provide it for you, because in California, you've got a right to know about what the other side has billed if they're going after you for attorney's fees. Now, in Texas, it doesn't appear to be quite that way. There was this Texas Supreme Court case on point from, I think, 2017, but I haven't really digested it because I'm not getting paid to digest it that closely. But in Texas, apparently, it's much more difficult to get the opposing parties' attorney fees, even a redacted form of them. So it is what would normally be considered to be, confidential information, because it is protected from disclosure in litigation. Now, the mayor did release these billings, so she did disclose them, but I don't think that's a big deal for three reasons, and I'm going to tell you the three reasons. Reason number one is that the client can typically waive the privilege. It's different than the duty of confidentiality by an attorney. The attorney can't just go ahead and waive, can't just go ahead and spill the client's beans. The attorney has a duty of confidentiality. The attorney-client privilege is different, though. It's an evidentiary privilege, and the client can waive it whenever the client wants to. And generally speaking, I'm assuming Texas has the same kind of structure that California and most other states do. The mayor is a city officer, and city officers can waive attorney-client privilege. Just like the president of a company can waive attorney-client privilege, or any, like the vice president probably can too. I mean, any corporate officers can typically waive the attorney-client privilege. And a city is a municipal corporation, and these city officers are corporate officers. So there you go. The mayor can most likely waive it. So if the mayor did waive it, it's not really a big deal. Does it divulge confidential information? Technically, I don't think so. I think it's a billing record that would be subject to FOIA anyway. So that's number two, is it could most likely be reached. Somebody could most likely request that billing information through a FOIA request, or whatever. I think Texas calls it their Open Government Act, or Government Open Records Act, Texas Open Records Act. I think that's what they call it. So it's not that big of a deal. And then number three is that the reason why the billing statements are generally considered to be privileged, why they are kept confidential, is because, again, you don't want the other side to see your strategy to be able to counter it. So if they get a hold of your attorney-client, or if they get a hold of your attorney billings, and they see that you were reading the case X versus Y, the case US v W, and the case ZVA, then they can read those cases, see what you're looking for, get the pattern. Oh, so this is the track they're going down. This is what they think is crucial to the case, etc. And they can devote their time and efforts to undermine that particular strategy. There is no underlying litigation here, so is it really that big of a deal that she released it? I don't think it is. I think in this case it sounds bad to say that they found that she violated their ethics code, but their ethics code is kind of vague. Now think about this. If attorney-client privileged information is confidential under Leon Valley's particular definition of what confidential information is, anytime a Leon Valley official says, on advice from our attorney, we're not going to be able to do X, or we're going to do Y, or whatever, that is divulging. That is divulging what would otherwise be privileged communications between the attorney and the client. That would literally be a violation of this confidentiality code that Leon Valley has implemented in their ethics section. So again, I don't think it's that big of a deal. It sounds bad, but there's a lot of smoke and noise, but there isn't any fire. So anyway, and I don't know if I mentioned this or if anybody else mentioned this, but they're not going to take action. She is the only person running for mayor. She is going to be reelected. It's not that big of a deal. It's just not a big deal. And it's not like they're trying to cover it up. It's been in the newspapers. I'm surprised that they found it to have been an ethics violation. I wouldn't have voted for it. I don't know the mayor. I don't care about the mayor, but I don't think that what she did would rise to the level of an ethics violation. Anyway, thanks for watching. Have a great day.